Hello, everybody. My name is Timothy Scott, or TJ Scott. I'm an estate planning attorney and the owner of the law office of Timothy J. Scott. I'm so happy to have you here with me today. We're going to talk about something that I know is a difficult topic. This is hard to talk about. It's hard to even think about. But I also believe that knowledge is power. And that's what I want to do today. I want to educate you, but really I want to empower you and give you some peace of mind around this topic, talking about end-of-life planning, talking about planning for a time when you might not have capacity to make decisions for yourself. I get it. I understand that that's scary. But again, I want to give you some peace of mind so that you have the information, you know what the future might hold, and you know how to address it and how to take care of it in a way that leaves you as well positioned to take care of it as you possibly can be. That's what we're doing here tonight. So today I have some really valuable information that I want to share with you. I also have some valuable offers that I'm going to be making at the end of the presentation about how you can get a tailored, custom designed estate plan in place for the people that you love. So please stick with me and we will get to that soon, I promise. The best way to learn tonight is to be present with me. And so I really encourage you to turn off any distractions that you have. If you have another window open, if you have the TV on, something like that, I encourage you to set it aside for this hour and give yourself this time that you've committed to being here. Be present with me. I always say your future self is going to thank you because this information is heavy and there's a lot of it. And it can be complex. I'm going to try and make it as simple as possible. I always do, but it can be a lot of moving pieces. And so I want you to be with me here. Devote yourself to learning this information, and you'll be really happy that you did in the future. I do see a question coming in. Are there other attorneys in my firm? The answer is no. I am a solo attorney, but I don't do it all myself. I do have some other estate planning attorneys that I partner with, and another estate planning attorney in particular who has agreed if anything happens to me, that he would take on my client files, and vice versa. If anything happened to him, I would take on his client files. So I am the only attorney in my law firm in the law office of Timothy J. Scott. Here are some of the offers that I'm going to make. The first offer is how you can get a free virtual one-on-one meeting with me to talk about the things you have and the people that you love and how you can protect them. And it's a really fantastic meeting. There's no obligation to write a plan. It truly is free, complimentary. I want you to have it because I want you to have this information. And I want you to have some comfort around the specifics, especially in your life. Plus, I have a bonus gift that that's gonna make it even easier to get a personalized, tailored estate plan put in place for the people that you love. But let's do this. I have some questions here. The first question is, do you have an estate plan? And if you don't mind sharing with me on this poll, it helps me to get a pulse for the room and to kind of have a better idea of what to talk about here tonight. So I'm saying mostly no's. The things that I have listed here on the slide are parts of an estate plan. And that's, I often get questions, well, I did a will, is that an estate plan? Or, I think we did a trust, but I can't really remember. Is that an estate plan? An estate plan is all of these estate planning tools kind of put together and oriented towards one purpose. What do you want to have happen when you become if you become incapacitated? And what do you want to have happen when you pass away? So parts of an estate plan, a trust, a will. If you have minor kids, guardianship nominations should be part of that estate plan. Healthcare directives, a power of attorney, and beneficiary designations. These are all classic elements of an estate plan. I think most of us probably have beneficiary designations if we have a retirement account or life insurance policy. Many of us may have done a will in the past. So I'm seeing most people are saying no, that they don't have an estate plan in place. In fact, by far, most people are saying that no, they do not have an estate plan in place. And so we'll talk about that. And we'll talk about what a will can do and can't do as well tonight, and whether it's a good fit for you or not. So if you don't have an estate plan in place, I want you to know that you're not alone. In fact, there are a number of people who don't have an estate plan in place in the United States, I think it's something like 69% of the population doesn't have an estate plan in place. But I'm going to pop another poll up here. You probably have seen it already. If you don't have an estate plan in place, why not? Does something here on the screen resonate with you? And you can choose multiple things if you want to as well. If you feel like you are just too busy, trust me, I completely understand how you feel. I'm a father of 4 kids. I own my own law firm, and life is really busy. I completely understand that. If that's the case for you, and I see some people sharing that, yes, they feel too busy, that's the reason that they haven't gotten an estate plan in place, I want to commend you for being here tonight. You have taken this time, you've set it aside to be here and learn about estate planning, to learn about wills, trusts, and guardianship and what it all means. And that's really the first step in making an effort and getting an estate plan put in place. So kudos to you. I'm glad that you're here, and I've got some great information for you tonight. Maybe you feel like you're too young, and I'm not seeing anybody saying that they feel like they're too young. And that's good, because truly there isn't too young of an age. As long as you're above the age of 18, you really should have an estate plan of some kind in place, at least a healthcare directive, power of attorney. I can tell you, I recently helped a young family, and the father didn't have an estate plan in place, and the father passed away. And he really left something of a mess behind for his wife and for his young daughters. But it didn't have to be that way. It didn't have to be such a mess. There were some fundamental things that he could have done. It wouldn't have cost a lot. And unfortunately, we had to do some cleanup after the fact. Maybe you're worried about it being too expensive. And I do see some people saying, yes, I think estate planning is too expensive. Well, before word processing, yes, estate planning truly was just for the wealthy. But today, with word processing, things like Microsoft Word and Google Docs, I think it's called, something like that, estate planning really is for everybody. It is approachable for everybody. And that's fantastic. We're living in a very good time for accessibility to things like estate planning. It's not just for the wealthy anymore. And really, everyone should have an estate plan in place. Now, if you're worried about the expense, I'm going to talk more about the costs that you should expect to pay for an estate plan. And again, I have some offers that I'm going to be making at the end of the presentation to make it even more affordable to get a great estate plan in place for the people that you love. Maybe you're worried about jinxing yourself, and I'm not seeing anybody saying that they're worried about jinxing themselves. That's great. I can tell you, I have done a lot of estate plans. In fact, I've done hundreds of estate plans, and I've never seen a correlation between somebody getting their estate plan done and having something happen, something negative happen in their life. Just haven't seen that correlation, which is good news. In fact, I say that my clients tend to live with more purpose. They tend to have that weight off of their shoulders. And so they're able to lift their heads up and live with more intention and live more purposefully. And I really have seen it. I've seen people with the relief that they get from having their estate plan and they know what's going to happen to their family. I've seen the gratitude and I've seen the comfort and ease with which they're able to live after that, because it's taken care of and they know that it's taken care of. So thank you everybody for sharing in that poll. I have a couple more polls that I'm going to pull up here in just a minute. I need to get to the next page. There we are. If you have a plan in place, and I saw most people don't have a plan in place, but if you have a plan in place, what is it that you're hoping to learn here tonight? And even if you don't have a plan in place, if something here resonates with you, I hope that you'll share that with me. If there's something else that you're hoping to learn here tonight, I hope that you'll put that in the chat or you'll put that in the Q&A so that I can see and speak directly to the question that you have in your heart here tonight. So maybe you have done an online will or a do-it-yourself will, and you're wondering, is that okay? Is that going to take care of my family in the way that I want my family to be taken care of? And I promise you, I am going to talk about that tonight. That's important. And it's important that you know what an online will can do and what an online will can't do. Maybe you're wondering, is my plan out of date? I wrote it back when I had minor kids, and now the kids are grown. Are they really going to have to go stay with Aunt Debbie if something happens to me and my wife now that they're 30 years old? And the good news there is no, they don't have to go live with Aunt Debbie now that they're 30 years old. She doesn't get guardianship of the kids, so don't worry about that. But there are definitely changes that happen in the law and changes that happen in your family and with your assets that can date a plan and make it where it's not the same service to your family and the same taking care of your family in the way that you want it to. Maybe you're just here to get a better understanding of your plan that you have in place or about estate planning in general. And I often hear this from people who have estate plans in place because oftentimes attorneys don't do a good job of explaining exactly what their plan is and means and what it says and how to understand it. A lot of times plans are written in legalese, and they're written in legalese for a reason. That's the language that the courts speak. If a court has to be involved, you want them to understand what the document says and to get the best treatment for you and for your heirs. But it's very important that you understand what your plan says and that you're fully educated and that you are the one making decisions about your plan. And I know, having a lot of people come to me who have had plans written by other attorneys, that that's not the typical experience. That's not the general experience of working with estate planning attorneys. And again, post in the chat or post in the Q&A if you have a specific question that you're hoping that I'll answer. Seeing kind of a smattering of is an online will okay? Somebody said, is my plan outdated? Somebody said, a few people said, I want to better understand my plan. So again, thank you for sharing in those polls. It's fantastic seeing your guys' answers and seeing your participation. So thank you for sharing tonight. I want you to know that you're in the right place here tonight. Wherever you're coming from, if you have a plan in place or you don't have a plan in place, if you've never even thought about having a plan in place before, whatever the situation, you're in the right place tonight. You're in the right place if you have someone or something that you care about and that you want to protect. And you're in the right place if you've done an online or fill in the blank will, but you're not sure if it's going to work, if it's really going to take care of your family in the way that you want your family taken care of. And you're in the right place if you're nervous about how much this is going to cost. I completely understand, and I am going to speak explicitly to the cost and to the expense so that you have a better understanding going forward of what that looks like and how you can get an affordable estate plan written for you. The reality is estate planning isn't about us. And these are three of my kids. It really occurred to my wife and I recently when we were updating our plan that the estate plan that we were writing wasn't going to enrich us. It wasn't like a new business venture or anything like that that might enrich us. It's really about them. It's really about the people that we love and making sure that they're taken care of when we're gone, or if we're incapacitated before we're gone. And the reality is, it's a gift that we're giving them, and they're going to know at the end of the day whether we've taken care of it, whether we have made sure that all the loose ends are tied up and that they're taken care of. They're going to have an idea. They're going to know at the end of the day. I'm seeing somebody say it's overwhelming, so I haven't done a plan, and I completely understand that. There are so many moving parts. In fact, I had a friend recently tell me, estate planner, people who try and do estate planning on their own, it's like putting together IKEA furniture without the instructions. There are so many pieces, there are so many parts, and each one serves a purpose and does something specific. But it is very hard to know how to put all those pieces together unless you work with a professional or do an enormous amount of educating yourself before you try. And so I completely understand. Thank you for sharing that I understand that feeling of overwhelm. And hopefully tonight, I'll at least give you some information and give you a feeling of empowerment where you know how to tackle this, you know how to get this taken care of. So thank you for sharing. Here are the things that we're going to cover today. We're going to talk about planning for incapacity, and we're going to talk about who can make healthcare decisions for you, who can make financial decisions for you if you can't make them yourself. For example, if you're in a coma or if you're suffering from dementia, for example. We're also going to talk about planning for when you pass away, and that's the more typical understanding of estate planning, is planning for when you pass away. So we're going to talk about guardianship in that context. If you have minor kids, who are they going to live with if something happens to you? Who's going to be able to take care of those kids, both in the short term and raising them until the age of 18, until they're able and ready to stand on their own feet? We're also going to talk about probate, and probate is a court case that happens after you pass away. We're going to talk about the time, cost, and public nature of probate and why Many people want to avoid probate and how avoidable it is. It truly is avoidable with the right planning ahead of time. Estate taxes, we'll talk about estate taxes. I usually get to give people good news when we talk about estate taxes because the estate tax exemptions are so high, they don't apply to most people. In fact, that's not the reason that most people do estate planning anymore. Estate taxes are not the primary driver of estate tax or of estate plans. There are other drivers, such as making sure that assets are going to the right person or avoiding probate. We'll talk about unclaimed property. We'll talk about how much is currently in the Minnesota Department of Unclaimed Property and how that money gets there. We'll also talk a little bit about your intangible assets and how you can make sure to share those with the people that you love after you're gone. I do want to launch one more poll here really quickly, just asking kind of demographics. I would like to know how many people have young kids in particular, because if there are a lot of people here with young kids, I want to make sure to spend some more time talking about that minor children aspect. But if most people have grown kids, then or no kids, then we'll spend a little bit less time on it. And I am seeing kind of a smattering, some people with young, some people with grown, some more people who have grown kids, but enough people with young kids that I think it's important to spend a little time talking about guardianship and talking about exactly what that means and how you can get that in place. Before I start jumping into that though, I want to tell you just a little bit more about me since we're going to be spending the next 45 minutes together. So this is my family, and like I said before, we live in Bloomington, Minnesota. My wife's name is Tobin, and my kids are Ben is the boy, and then from left to right, it's Elizabeth, Margaret, and Bridget there. And Bridget's our newest. She was just born in April. She's 8 months now, or nearly 8 months now, and she's adorable. And I see somebody saying my kids are 19 and 18, so grown, but not on their own. And that's true for so many people. But because they're not under the age of 18, guardianship is probably not the issue that it might be for others. So beautiful family. Thank you very much. Thanks. So I graduated from the University of St. Thomas School of Law in 2012, near the top of my class. And the next day, my first child, Ben, was born. And there you can see me commencing on May 12th and holding my son for the first time, one of the first times, on May 13th. It was a really happy day. After law school, I found a job with a small estate planning and tax preparation law firm in Minneapolis. And I love the clients that I was able to work with. But sometimes I didn't feel like we were providing the value to those clients that I thought that the clients deserved. And so a little after 3 years there at the law firm, I actually left. And this is a picture from my last day at that law firm. Someone has to graduate at the bottom of the class. Now, this, I just want to say, was not said about me. This was something that was said about another estate planning attorney. In fact, it was an estate planning attorney who helped with my grandmother's estate. And it was a really frustrating experience for my family to the point where this was their takeaway. Someone has to graduate at the bottom of the class. That's the only explanation for why things have gone the way that they've gone. The truth is, I don't think that attorney graduated at the bottom of their class. I think they were trying to practice estate planning under kind of a faulty model. I call it planning for death. And I am going to talk about that a little bit later. But first, let's talk about some aspects of estate planning. And the first aspect of estate planning that I always want to talk about is guardianship, because it's so important for people with minor kids. And there are two types of guardianship that I'm going to talk about. The first is short-term guardianship. And the way to think about it is you leave the kids with a babysitter, there's no plan in place, and for whatever reason, you don't come home. And the hours tick by, 10 o'clock, 11 o'clock, midnight, and the babysitter is getting more and more concerned. Eventually, the babysitter is going to call the police, and the police are going to call Child Protective Services to come and pick the kids up and keep the kids for a time. Now, I don't know about you, and I'm not trying to rag on Child Protective Services, but I don't want my kids spending any time with Child Protective Services. I always want my kids to be spending time with somebody that they know and trust, a family member or a friend. And that's why this short-term guardianship is so important. You can get a plan in place. You can get legal documents in place that say exactly who those kids can stay with legally, where the police can feel comfortable leaving the kids with your sister or leaving the kids with your brother or a neighbor or somebody until you can be found and you can be brought home. So that is very important, that short-term guardianship. Avoid your kids having to go and spend times with Child Protective Services. It's not a good situation for most kids. Instead, make sure that you have a plan in place. Long-term guardianship, on the other hand, is who is going to take those kids and raise them until the age of 18. Who's going to love them like you would if you were there, but no longer can. Where are the kids going to flourish? Where are they going to thrive? And the truth is, if you don't have a plan in place, a judge is going to decide. There is a plan there. The state of Minnesota has a plan, and that's to allow a judge to decide for you. And that means if the judge decides that Uncle Larry has the best situation, Uncle Larry has the best situation possible for the kids, and Uncle Larry is going to get the kids, then Uncle Larry will have the kids, even though you know Uncle Larry should never be allowed anywhere near the kids, right? And so it's very important to have a plan for long-term guardianship in place. And we can do both of those elements. We can do the short-term guardianship, long-term guardianship, and make sure that that's legally documented to protect your kids and make sure that they have somebody to stay with in the immediate and also the long term. All right. Try to keep that guardianship portion brief so that we can talk about things that apply to almost everyone. And that is this section in particular here applies to almost everyone. We'll talk about how people will receive your assets after you're gone. And the first thing that we're going to talk about is a court process called probate. And this is the state's estate plan for you, is this usually administrative court procedure. There's a way of describing this. It's a lawsuit that you file against yourself with your own money for the benefit of your creditors. And that's really what it's for. It's to make sure that your creditors have time to come forward, make their claims known, and get paid. That's the purpose of probate. And probate is slow. In Minnesota, probate takes at least 6 months. More often, it's taking something like 12 to 18 months. We'd like it to go faster, but the truth is, it just can't. It's built with certain slowdowns in it, and the courts are getting overwhelmed. And it's taking longer and longer for the courts to get to the cases and to actually hear the cases and get them resolved. It just takes a very long time. It's also very costly. There are attorneys' fees and executors' fees, appraisers' fees and court filing fees, bond premiums, creditors' claims. There's all these different things that go into, that need to be paid out of your probate estate. And we estimate in Minnesota that probate costs somewhere between 3 to 6% of the gross value of your estate. So you can imagine if you own a house that's worth $400,000, and to some people that's a very nice house. To a lot of us, especially with the way that real estate has really inflated, it's a pretty typical house. You imagine that you have a house that's worth $400,000. Already, you're looking at probate costs of somewhere between $12,000 and $24,000. That's the 3 to 6% range. And I can tell you oftentimes it's closer to that $24,000 with attorney's fees. And if you consider the utilities that continue running on it, mortgage payments that continue to need to be made, real estate taxes that don't stop just because the property's in probate, it can get very expensive. And we'll actually have a chance to calculate our own probate estate in just a little bit. Probate is also public. So this is the last will of Anna Nicole Smith. And I was able to access this because the will had to be filed publicly and the court had to open that filing up so that anybody who wants to see it can see it. And there are other documents, there are other things that get opened up as well that you might be surprised about. For example, the court has to file, or somebody, the personal representative with the attorney has to file an inventory with the court. And that inventory is made public to everybody so that everybody can see the assets that you had in your estate when you passed away. There's also something called a final distribution or a final account and distribution. And that final account says, this is where all of the assets are going to go. And it numbers the amount of the asset and who is going to receive it. And you can imagine there are predators out there who find this information very interesting. They find the information that somebody who's unprepared for wealth or unprepared to receive assets is going to be receiving a large lump sum of assets from a probate. Unfortunately, that's good news to creditors. If you do have minor children, then those minor kids can receive the assets at age 18 and completely unprotected. And we all know stories like this of people receiving too much money at too young of an age, and it disturbs their understanding of finance and their ability to take care of themselves later in life. In fact, my mentor had her husband receive $50,000 when he was 18 and another $150,000 when he was 21. And as a result, he didn't end up graduating college until he was in his 30s, and he never really got his finances in order. They were always just kind of a mess because he didn't completely understand the importance of working hard and saving money when he had all of that money coming to him at such a young age. All right, well, here's an opportunity to calculate your probate estate. And I'm not seeing any questions right now, but again, just a reminder, if you do have questions, I hope that you will put those either in the chat or the Q&A because I'd love to see them. Excuse me. All right. So here's a chance to calculate your probate estate. These the assets that go through probate generally are assets like this. They're assets that don't pass by beneficiary designation. So they're things like the home generally doesn't pass by beneficiary designation, generally has to go through probate. A rental property or a cabin property would also generally have to go through the probate process. Furniture and household goods, automobiles, stocks, bonds, and bank accounts, and business interests, none of these generally pass by beneficiary designation. Almost always, they have to go through the probate process in order to get to your heirs, to your loved ones, to receive. And so if you just estimate, you can get 5% of the gross estate by moving the comma over one place. So instead of 850,000, it's 85,000. And then you cut that number in half. And so that's how I got this estimated probate costs and fees of $42,500. And I see somebody asking, what about TOD? And that could be either a transfer on death deed on the home, which does act as a beneficiary designation. It transfers the property when you die automatically. That automatically, by force of law, it goes to the person that you've elected to receive. The same with joint ownership. The joint ownership automatically transfers it. And in those cases, you don't have to worry about that asset going through probate. If you have a TOD, a transfer on death deed, or if you have a beneficiary designation, it's going to happen automatically. But most people don't have transfer on death deeds on their home. Another thing that could be interpreted as saying is transfer on death, which is something, or pay on death, which you can put on a bank account. And again, with a pay on death or a transfer on death on a bank account, that asset automatically goes at your death to whoever you have listed as the POD or the TOD in order to receive. However, most people don't have that POD or TOD listed. And it can get really complicated to keep them all, keep track of all of those PODs and TODs that you might have out there, including on your home. There are some other complications to having a transfer on death deed on your home that I'll try to talk about in a little bit, but I don't want to get too into the weeds about it right now. Here is a little bit of a wrinkle. If you have life insurance or retirement accounts that are payable to a minor, unfortunately, a minor cannot receive in Minnesota. They are not able to receive. And so that life insurance or retirement account often has to go through a process called conservatorship. And that conservatorship is burdensome just the same way that probate is burdensome, and it costs a lot. And there are accountings that the conservator has to make every year. It gets very burdensome and very expensive very quickly. One thing that I also want to point out here that I haven't pointed out yet, talking about probate, a will does not avoid probate. In fact, we have this extremely nerdy saying in the estate planning community, where there's a will, there's a probate. I cringe. I always cringe when I say that, but that's the saying that we have in the estate planning community. If you are relying on a will to transfer your assets at your death, then that will is going to have to go through probate. It has to be interpreted by a probate court. The probate court has to see who you've nominated as the personal representative and raise that person to be personal representative, because you're only making a nomination in a will. You're not actually appointing that person. It's actually the court who appoints that person to stand in your shoes. And generally they'll accept the nominated personal representative, but not always. And it can happen where they won't accept a personal representative for whatever reason. Maybe that person is out of state and can't qualify for bond, something like that, where they won't accept your personal representative. And I bring that up right now because even though a will doesn't avoid probate, there is something that does avoid probate. In fact, there's a foolproof way to avoid probate, and that's by fully funding a living trust. And I always do this demonstration. I think that it's really important to understand what a trust is. The simplest version of what a trust is that you take assets. I'm going to try and get them in the screen here. You take assets. In fact, maybe I'll even go big for this one. So you take assets that you own and you give them to someone else, okay? And this person who started with the assets is called the settlor, or the creator of the trust. And this person who accepts the assets is called the trustee. And the settlor says, I'm giving you these assets, but I'm giving you these assets on the stipulation that you do this with them. You follow these rules with those assets. And the trustee says, yes, I'm taking the assets under the agreement that I'm going to follow the rules that you've laid out and do that with the assets. That's the simplest version of a trust agreement, okay? Is that these two parties have come to an agreement. One person has taken property from the other one only to hold it in trust and to use it for the purposes that the original holder of the property laid out in that agreement, okay? That's the simplest version of a trust agreement. I hope that you don't mind me wagging my hands in front of your face so much. But obviously, that's the simplest version, that kind of oral agreement with an estate plan trust, with a living trust that we would write. We would obviously write it down. We would write all of the rules and all of the different definitions and interpretations, and we would provide a fully fleshed out, clear trust to your trustee. So they know exactly what to do. No matter what situation arises, they have exactly the information that they need in order to take care of it and administer your trust and administer the properties that they're holding on to in your name the way that you want them to. The interesting thing about a living trust is that you are both the settlor and the trustee. But obviously, as a trustee, you're kind of wearing a different hat. You have different roles and responsibilities than you did originally as the original person. So you're entering into an agreement between yourself with your property and yourself, who's now holding on to your property and following the rules that you laid out in this trust agreement. But when you pass away, somebody else can step into your shoes immediately. In fact, you can name that person who's going to step into your shoes, and it happens automatically. There's just something that they sign. It's called an acceptance of trusteeship. There's some affidavits and a couple of pieces of paper. Very simple to do. You don't have to go before a court in order to become a successor trustee. It's a much simpler process than probate. It's also very important that you fully fund that living trust. So I keep doing this demonstration where I'm handing these pens from one hand to the other hand, right? And that's very important. You have to make sure that your property gets to your trustee so that your trustee has the authority to act on that property. Now that the trustee is holding the property, they can do what they need to do. And so in order to fund your trust, in order to make sure that it is in the trustee's hands, you need to do things like retitle investment accounts. You need to go to the bank and sign new signature cards at the bank. You need to execute deeds to real property so that that real property is transferred into the name of your trust. And you have to transfer stock and bond certificates by filling out. It's usually on the back of that stock and bond certificate if it's a paper certificate. Otherwise, if it's an online digital certificate, there's generally a way that you can transfer that asset into the name of the trust through the portal. and assigning personal property, saying, I hereby give all of my personal property to so-and-so, the trustee, to hold according to this trust agreement. And then for life insurance and retirement accounts, you change the beneficiary designation so that those things point to your trust. And after you die, the trustee can take possession of those assets and administer them in the way that you want those assets administered. So I know that this is complicated. I know that this is a lot of information in a very short amount of time, but I promise you, this is so simple for families. It's so simple after you're gone for your family to be able to administer and take care of your assets and make sure that they're distributed to the people that you want. It is much simpler than having to go before the court and have that court look at and interpret your will and see possibly different meanings in it than what you really intended, and have your personal representative spending hours having to go through things, going through court processes and filling out forms, having to hire that attorney. It is so much simpler, and it can be handled really quickly and really easily in private with your attorney, with that living trust. It's fantastic. It is a great deal for your family. So please let me know if anyone has any clarifications that they want about what a trust is or about how you can use a trust to avoid probate. I'll watch for those, but I am going to move on here to talk about estate tax. And here, again, I get to give people good news generally, because we have an estate tax on the federal level and we have an estate tax on the Minnesota level, but those estate taxes don't apply to most people. On the federal level, the rate can be very high. It can be up to 40%, meaning 40 cents on the dollar that's going to your heirs is taxed and taken away by the federal government. But the federal government doesn't start taxing that money until you have more than $12.06 million. And in fact, if you are married, you get to double that number. So really that number for you would be $24.12 million. It is a vast sum of money. Most people don't have to pay federal estate taxes, which is good news for us, right? On the Minnesota level, the exemption is lower. The rate is also lower. The rate is somewhere between 13 to 16%, but the exemption kicks in at $3 million. And there isn't as easy a way to double that exemption. It doesn't happen automatically like the federal estate tax exemption does, but you can double that exemption with some planning. And so if you have more than $3 million, I'm not going to spend a lot more time talking about that right now. If you have more than $3 million, I encourage you to reach out to me and find out what you can do to apply some estate tax planning to your estate to make sure that you're either able to double that exemption if you're married, or to plan to have less estate taxable estate at your death, so that your heirs, so it doesn't have to come out of your estate, so that as much as possible can go to the people that you love. If you have more than $12 million, I hope that you've already reached out to me, because you really need to get some work done. Again, the rate can be up to 40%. It is very expensive to have an estate taxed at that federal rate. And so I really encourage you to get something done about it if you have more than $12 million. Let's talk about this. Will your assets be lost to the state? Does anyone have any idea how much money is currently in our State Department of Unclaimed Property? The answer, I didn't give you any time to actually guess, but the answer is over $700 million. And what does that mean? Well, unclaimed property generally happens when somebody passes away and their heirs, their family, the people who love them and try to collect their assets, aren't aware of where all of the assets are. And this is actually something that happened in my family, that my grandfather passed away in 2001, and my family was responsible for collecting all of his assets, inventorying them, paying any debts, and then distributing out the assets between the children that my grandfather had. And they did the best that they could. They collected all of the assets that they could find, different bank accounts. He banked at different banks, different stocks and retirement accounts, and all of these different things. They collected as much as they could, But while they were collecting, there was one asset that they missed. It was some Unisys stock. And that Unisys stock also was generating dividends. And so, unfortunately, after a certain amount of time, that property went to the Minnesota Department of Unclaimed Property. And they list it. There's actually a list out there that you can search by name and see if there's property out there in a loved one's name. My family was able to find this unclaimed property, but they still haven't been able to recover it. Again, my grandfather passed away more than 20 years ago, but it is so burdensome to try and recover property that has been lost and that is now with the State Department of Unclaimed Property. And it doesn't have to be that way. I believe as an estate planning attorney that I owe to my clients creating an inventory of their assets to make it as simple for their heirs, as simple for their family, friends, kids, whoever it is who needs to come in and collect the assets after they're gone. I think that that is very important, that we lose nothing to the State Department of Unclaimed Property. And I think this is especially important for people who have a modest estate, that if you don't have millions of dollars that you're planning to pass along, then it's very important that they get everything that you have to pass along. And the best way to do that is by creating a really clear and comprehensive inventory of your assets, keeping it secure with somebody like myself, an attorney who has security implemented. And that way your heirs will be able to find everything after you're gone. Oh, and this is really cool. So you can actually make your living trust a real treasure chest, and say that 10 times fast. What I mean by that is you can give your kids or the people that you love asset protection over the assets that you're giving them as a gift. And that asset protection means that you can protect that inheritance from things like a bankruptcy, having to go through a bankruptcy and creditors, or from something like a spouse in a divorce. You can provide that protection over that inheritance where the person can still use it and enjoy it the way that you want them to, but a divorcing spouse isn't going to get access to it. It's very cool. Not all attorneys are building in this asset protection or have the capabilities to do it, but I think that it's a great gift and a great opportunity for the people that you love to have that asset protection built in. This is something that is very real to a lot of us right now. Planning for incapacity and planning in particular here for your healthcare wishes. So the person pictured here is Terry Schiavo, and I don't know if everybody remembers. I don't know how many people remember, but I'm always surprised that more people remember than I would expect. But Terry Schiavo was somebody who in the mid-2000s suffered a cardiac event and was in a vegetative state. And her family disagreed about what should happen to her. Her parents thought that Terry would want to go on living in this vegetative state. Her husband thought that Terry wouldn't want to live in this vegetative state, that she would want life support ended and she would want to be permitted to pass peacefully. That's what the husband thought. And so there was a big fight, and there was a big fight that occurred in Florida and percolated all the way up to the Supreme Court. It led to conversations and arguments at dinner tables all over the place across the United States. All this court and conflict, worried about Terry Schiavo and worried about what her wishes would have been because Terry didn't let us know. She didn't record what her wishes would be in that case. Eventually, her husband won out. Terry was taken off of that life support, and she eventually passed away shortly after that. Within a week or 2 weeks, Terry was gone. So that's what happened in Terry's case, but it didn't have to be that way. Again, if Terry would have made her wishes known in something like a healthcare directive, then it would have been clear for everybody, for her parents, for her husband, for everybody across the United States about what Terry wanted in that situation, and her healthcare providers would have carried it out. So we've talked about a lot of things tonight. We've talked about guardianship for minor kids, and we've talked about probate. We've talked about how people often want to avoid probate to avoid the time that it takes, the lengthy time that it takes, the amount of money that it costs, and the public nature of probate as well. And we've talked about taxes, and we've talked about estate taxes don't apply to most people, but some people they do apply to. We've talked about the fact that probate is completely avoidable with something called a living trust, that it is something that you can completely avoid, but obviously you have to do some planning in order to make sure that your family is able to avoid probate. We've talked about unclaimed property and how property becomes unclaimed and the importance of having somebody who can inventory your assets and maintain that inventory for the people that you love for after you're gone. And we've talked about asset protection and this gift that you can give your kids and that you can build on the inheritance that you give them so that they can enjoy that inheritance and it doesn't go to a creditor in bankruptcy. It doesn't go to a divorcing spouse. And just recently, we talked about incapacity and planning for the kinds of healthcare decisions that you would want made on your behalf, and the fact that you can document those so nobody is left guessing, but what you want to have happen is carried out. Talking about all of these things, if something resonated with you, you're probably wondering, what can you do today to do the right thing for your family, and what should it cost? And again, if something resonated with you, if something stuck out to you and you're thinking, I need to do something, I need to get a plan in place in order to address this, you're probably thinking either I can do this myself or I should probably work with a lawyer. And how do you decide between those? How do you decide if it's something that you can do yourself, or how do you decide if you really need to hire a lawyer? And keep in mind, not all lawyers are the same. And we'll talk about that in just a minute. Well, obviously, I am an estate planning lawyer, so I am a little bit biased, but I want to try and help guide you through this decision. And so, would you benefit from working with a lawyer? Would you benefit from working with an attorney? In the first place that I generally start is if you have more than just your personal belongings, if you have more than just cars and clothing, jewelry and furnishings, then you would probably benefit from working with an attorney. When you get to the point where you own real estate, you almost certainly would benefit from working with an attorney. And if you have holdings that are above $75,000, then you're starting to look at probate, and you're starting to have that be a concern, and you would probably benefit from working with an attorney in order to avoid that process. If you want to ensure that the people that you love stay out of court and out of conflict, and that they have someone to turn to when something happens to you, then you need to work with an attorney in order to give them that counselor that they can turn to after you're gone in order to help them resolve things. If you want a kids protection plan, which includes that short-term guardianship, long-term guardianship, if you want to avoid probate or estate taxes, or you want to protect your children's inheritance with asset protection, then you have to work with a lawyer. Those are not things that you can do in a do-it-yourself estate plan. You really have to work with an attorney in order to get those done. And if you want to guarantee that your plan is going to work when your family needs it, then you have to work with an attorney. And I think this is such a big thing. I have done a lot of do-it-yourself projects in the past. And in fact, one that I like to tell the story of, my son and I were going to go fishing. My son wanted me to take him fishing, and I had ordered 2 new fishing rods and reels and had them shipped to me. They came to me, they didn't have fishing line already on them. No big deal. I ordered some fishing line, and I was going to put that fishing line on the rod and reel. And I started winding it on, and everything seemed to be going well. But when I finally got enough onto the reel, I went and clipped the end, and all of a sudden, I still don't know what I did. All of that fishing line, not all of it, a lot of the fishing line started jumping off of the reel and was a tangled mess on the table in front of me. So that's an example of a do-it-yourself project that went wrong, but it was a good do-it-yourself project, and here's why. The only thing that I lost from that do-it-yourself project was about 30 cents in fishing line. I had to clip it because it was so tangled, there was no way I was going to be able to recover it, but it was about 30 cents worth, not a big cost. And I had immediate feedback that I had failed in my effort to get that fishing line onto the rod and reel. It happened immediately, and I knew immediately that something had gone wrong. and that I needed to fix something. And guess what? I was able to fix it. That same morning, I was able to fix the rod and reel and get it set up so that my son and I could still go fishing. I was there. I was able to fix it. Not a problem. The reason that I bring up that story is because estate planning is the exact opposite on all of those things. If you make a mistake, you aren't going to be there to clean it up. You're not going to have immediate feedback that something even is wrong. In fact, your family is going to be the first ones to learn about it after you're gone, that something was wrong with your estate plan, that there was a mistake and things aren't going to go smoothly. And again, you're not going to be there to fix it. And it's probably going to be costly because those are the types of errors. Errors in an estate plan tend to be very costly for the people that you love, and also kind of a headache. They take a lot of time and they take a lot of effort to fix. That's a do-it-yourself example of why you may not want to do estate planning yourself, but thinking about working with an attorney, what should you look for in the attorney? And I want to bring us back to this quote. Someone has to graduate at the bottom of the class. Again, this was not said about me. This was said about an extremely negative estate planning experience that my family had in planning my grandmother's estate, working with my grandmother's estate planning attorney. And again, I don't think it was that this attorney had a lack of knowledge. I think that they were working under a faulty model. I call it planning for death. And that's the typical estate planning experience that most people get. In that experience, you get form documents that are kind of set it and forget it. It's likely that the attorney never went through those documents and explained them. The attorney might not even understand those documents themselves. They just plug your name in certain places, hit print, and assume that everything is going to be okay. That's the typical experience, those kinds of form documents. The typical experience isn't going to keep your money out of the Minnesota Department of Unclaimed Property. It's just not something that most estate planning attorneys see as in their realm of concern, that most estate planning attorneys just don't think that that applies to them, that that's not something they need to worry about. Most of them are very focused on those documents and just getting those documents executed, printed, and signed and getting you on your way. Typical experience may avoid probate, but may not. In fact, I actually learned this at the estate planning law firm that I was working at. Even when we wrote trust agreements, we didn't always avoid probate. And the key was that the trust wasn't always fully funded, either initially or over time, something would happen and the trust would no longer be fully funded. And because something was left out of the trust, it meant that a probate had to happen. And I think that that is underserving clients. If you are looking to avoid probate, it's very important that you work with an attorney who can help you do that. Typical experience probably isn't going to keep your family out of conflict. It's just not something that most estate planning attorneys put attention on. Most of them focus on money. They don't focus on things like your family and your family dynamics, nor on things like your stories and your values and how you can share those with the people that you love. Typical experience is going to leave assets to heirs unprotected without that asset protection that we talked about. Typical experience isn't going to have ongoing legal guidance. And the big reason is because they're going to charge hourly fees when they do your estate plan, and they're going to expect to charge hourly fees for any future needs that you have as well. And those hourly fees add up quickly, and they send a message you don't want to contact your estate planning attorney. It creates a rift in that relationship, which can't be there if you want your estate plan to work for you when it needs to work. And the typical experience isn't going to adequately protect the kids. It often puts that long-term guardianship in place, but not the short-term guardianship. And it leaves you with this question: will it work when you need it to work? And that's clearly not a question you should ever have when you've worked with an estate planning attorney. Planning with me is totally different. I call it planning for life, and it's a completely different experience from the start. I charge all flat fees, and I let my clients choose the fee. And that doesn't mean that you're just paying me from goodwill or anything like that. I have different flat fee packages that I offer, and I will talk you through those different flat fee packages and tell you what comes with each one and what it means for your family. And then you choose based on what you want for your family and based on your finances, And whichever fee package that you choose, I'm happy to write you an estate plan under that fee package. Planning with me is going to keep your money out of the hands of the state. We're going to make sure that we inventory your assets and that everything you have goes to the people that you want it to go to. That's very important, as like I say, especially if you have a somewhat modest estate, that you're able to pass every dime to the people that you want it to be passed to. Planning with me protects your kids totally. If you have minor kids, I make sure to do, we do what's called the Kids Protection Plan, which protects them in the immediate term, as well as the long term. Planning with me means keeping your family out of court and out of conflict. And that is essential to me. I am at heart, I see myself as a peacemaker, kind of strange for a lawyer, but I see myself as a peacemaker. And that's really what drives me to do what I do, that I want to keep the peace in the family. I don't want families to fall apart from conflict. And so I do focus, I spend time focusing on things like family dynamics and making sure that you are able to avoid court and you're able to avoid conflict in your family. Planning with me means knowing that you've made the right decisions, because I don't make those decisions for you. I'm not giving you form documents that I just plug your name into. I'm going to walk you through what your estate plan is and what it means and allow you to make the decisions. And I'm going to educate you so that you have the information that you need. And I'm going to empower you to make those decisions so that your estate plan is your own. Planning with me means that you can protect the family money from outsiders. We can build in that asset protection to provide the protection from a divorcing spouse or from a creditor. Planning with me means a lifetime of guidance and protection, because I'm not going to bill you hourly bills in the future for picking up the phone and saying, TJ, I'm just trying to remember what's the name of my trust, or TJ, who is it that we had listed as guardian? I want to make sure that I have the right person in mind. Not going to charge you for those phone calls, for those emails. If you make changes to your plan in the future, then we'll talk about what a reasonable fee is to make changes to that plan. But again, we're living in an era with word processors, so I can promise you it'll be reasonable, and we'll come to an agreement about what's reasonable to make those changes to your documents. Planning with me, it means that your plan's going to work when your family needs it to work. And it's really, again, a gift that you're giving to the people that you love the most. And I told you, I completely understand concerns about expense, concerns about cost, and that's why we're going to talk about it right now. And let's start here. If all that you have is a house that's worth $400,000, again, I know for a lot of us, that's a very nice house. For some of us, that's about an average house, and for some, maybe that's even a modest house. But if all that you have is a house worth $400,000, this planning is already going to save your family at least $12,000. That is 3% of the $400,000. That's the bare minimum of what probate is probably going to cost. If you have assets over $3 million here in Minnesota, this planning is going to save at least 13 cents on the dollar for every dollar in excess of $3 million. The typical death plan with a typical estate planning attorney costs a minimum of $1,500. And the truth is that that's ticking up now, where $1,500 is an extreme minimum. You have to be very suspicious if somebody is writing an estate plan for you for only $1,500. And in that case, you can be almost guaranteed that it's not going to keep your family out of court or out of conflict. It won't ensure your assets aren't lost to the State Department of Unclaimed Property. It's only going to cover your money, not your kids' immediate care, not your values, insights, stories, and experience, and making sure that those are shared with your family. And those are really the most commonly lost assets, those types of values, insights, stories, and experiences that I think are really important. The alternative is you can plan with me. I'm a personal family lawyer, which is a nationwide group of us who believe in having strong, clear relationships with our clients, where communication is central and foremost. And you can learn specifically what your family needs. Again, it's my mission to educate you and empower you to put in place an estate plan that serves your interests and serves your family's interests. And you can choose your own fee. That fee is likely to range somewhere between $2,000 and $8,000. and you're going to know that the plan will work when your family needs it to work. I can tell you the range is vast, 2,000 to 8,000. I can tell you most people fall at about $4,000 or $5,000 or less. That's where most people fall on that scale. And I want to make it really easy for you. And so I'm actually going to go ahead and post a link here so that you can see what my calendar looks like and see if there is some time available on there that you can snag a meeting with me, because I want to give you this meeting for absolutely free. It has a $750 value because it's a 2-hour-long meeting with me, but I want to give it to you just for attending today, committing to reserve your family wealth planning session and turning in a little bit of pre-work ahead of time just to make our session really efficient and really effective. And I want to give you this no charge family wealth planning session. It is completely free. There's no obligation to go on and write a plan with me, although most people who do the family wealth planning session do choose to complete a plan. And that's what's in it for me, is I'm hoping to earn your business. If there is something about your current estate plan, or if there's something about the state's estate plan that you don't like, and my prices are at such a level that it makes more sense to get something done, to pay me to get something done, than to just grit your teeth and bear with whatever the state's plan or your old estate plan says, then I want you to hire me and I want you to work with me. And if you do choose to hire me and you do choose to work with me, I want to go one step further and I want to give you $250 towards the estate planning package of your choice. All you have to do to get that $250 towards the plan of your choice is reserve your appointment before the end of the week. And when I say end of the week, what I'm talking about there is the end of the day, Saturday. And I will follow up with some emails between now and Saturday saying, have you reserved your time? Have you got your family wealth planning session with me yet? But the best thing that you can do is click the link right now or scan the QR code with your phone. Hopefully it works, and you can see what my calendar looks like, and you can see where there might be some time where you can come in and meet with me. Again, that family wealth planning session is absolutely free. There is no obligation to continue and write a plan. My hope is that, and what I've often found is that when you come in and you hear what the state's plan is for you, or you hear what your current estate plan says, and it's not what you want it to be, that you realize how easy it is to work with me, how simple I can make estate planning for you, how clearly I can explain everything and walk you through everything, and what a great resource I would be for your family if something were to happen to your family. And realizing all of those things, most people, like I say, do choose to hire me out of that family wealth planning session. And here's what my clients say after they hire me. They are overwhelmingly positive, and I get a little shy about sharing some of this. So I'm just going to let you read some of the comments that clients have made in the past about working with me. And I want to talk a little bit more about that family wealth planning session. So the family wealth planning session is totally virtual. We do it over Zoom, kind of like this, except I'll be able to see you and you'll be able to see me. We talk, we get acquainted a little bit, and then we talk about things. We talk about who would be the person to collect everything for you. Is there somebody in your life that you think of that would fill that role, who would collect everything, keep everything organized, pay some expenses that you have, and then make sure that everything is distributed the way that you want it to be distributed? We talk about what would happen if you became incapacitated. And we'll talk about conservatorship, and we'll talk about guardianship. Those are two court cases that happen if you don't have a healthcare directive or a power of attorney in place. Those court cases have to happen in order to get somebody in a position where they can make decisions for you, whether that means writing checks on your behalf from your checkbook or making healthcare decisions for you and deciding whether to keep you on life support or not. We'll talk about probate. And we'll talk about what probate looks like for you, whether your estate as it's set up right now would actually have to go through probate, and if so, how time consuming and how expensive would it actually be. We'll also look and see if you would owe estate taxes. Again, the number here in Minnesota is $3 million. There's a $3 million exemption. The federal exemption is $12 million. They don't apply to most people, but if they apply to you, we want to make sure that we have a plan for how we tackle that and how we minimize the amount of estate tax that you will have to pay, or that your family will have to pay. We talk about how you want the people that you love to receive the assets, whether you want them to receive those assets outright, whether you want them to receive it over a period of time, or whether you want to build in that asset protection over the assets in order to take care of it and make sure that that they are able to enjoy it and not have it enjoyed by a divorcing spouse or a creditor in a bankruptcy. After the family wealth planning session, I'll confirm everything with you in a confirmation document. I draft your documents, and because I have a virtual office, I come to my clients for the signing meeting, or we meet at an office space that I have, a virtual office space that I have, where we can use a conference room. That signing meeting is when your documents are effective. And we can get those documents effective just 4 to 6 weeks after your family wealth planning session. We can do this, we can get it done. And you've probably by now, you've probably clicked on my link and you've taken a look at my calendar and you've seen I do not have any availability in December. And unfortunately, I don't think that I have any availability right now in January. And so you're probably looking at February if you want to schedule with me. But you can imagine if we're meeting in February for the family wealth planning session, you could have documents signed and sealed in March. I don't know why I said sealed. You don't seal documents. You could have documents signed, executed, and effective in March. And you could know in March or early April that your family is being taken care of, that there is a plan in place, that you don't have to worry anymore because they are being taken care of. After that signing meeting, there is a third meeting as well, the Family Wealth Legacy interview. And that's the meeting where you get to share with me about each other and about some of your stories and your values. And we capture those things in a recorded interview. We also make sure that funding your trust is going well if you've chosen a trust plan, and that I can troubleshoot any issues that you've run into with that. So again, next steps. Your next steps are to schedule your free family wealth planning session and come to that family wealth planning session. And if it makes sense to hire me, if I can help you and if I can do some good for you, then use the $250 you've earned by reserving that family wealth planning session before the end of the week to use that $250 towards the plan of your choice. Now I'll look over here and see if there are any questions. I'm not seeing any questions. It's been kind of a quiet group tonight, in fact. Usually there are a few more questions of this. And I just want to encourage people, if you have questions, now's the time. You have my ear, and I am happy to answer questions that you have right now. I hope that you'll bring them to me. A few things that I often hear, a few things that we often talk about. One of those that we heard a little bit about earlier tonight is what's called a transfer on death deed. And a transfer on death deed is fantastic. It hasn't been around for a very long time in Minnesota, but it is something that Minnesota has added somewhat recently that is really fantastic and a great planning tool that is part of the arsenal. Transfer on death deed attaches to your home. You record it like you would a regular deed. So you record it with the county recorder or the registrar of titles. And when you pass away, that transfer on death deed becomes effective and automatically transfers your home or whatever real estate it's attached to the person, the beneficiary that you've listed on that transfer on death deed. It's fantastic. The only places where I say exercise some caution with that transfer on death deed is when you have it going to more than one person, or if it is going to a minor person. You can't have it going to a minor. A minor can't take possession of real estate. And so things are going to get really complicated if you've directed a transfer on death deed to a minor. That one, I think, is pretty clear. The other one, having a transfer on death deed go to multiple people. And the reason is this. If you have a transfer on death deed that goes to 2 kids, 3 kids, let's say, those 2 or 3 kids are all going to have to agree about what happens with mom and dad's house now. They're all going to have to come together and agree it's time to sell the house. It's time to have so-and-so move into the house. It's time to put the house up as a rental. Let's Airbnb the house. There are all these different options about what can happen to the house, and it can create a lot of conflict between the siblings. And here's what's even worse. The siblings' spouses get to be involved in the discussion as well. And the reason for that is here in Minnesota, spouses have an interest in the real estate that is owned by their spouse. And this is, I think originally it was intended to be the homestead, that we want to make sure that if the wife owns the homestead when the 2 get married, that the husband has some sort of interest if the wife is trying to sell the house out from underneath him, right? That we want there to be some kind of interest between the spouses. But how it's transpired is that spouses in general have an interest in the property, in the home, in the real estate property that the other spouse owns. So now instead of having 2 kids or 3 kids have to come to a decision, you have 4 kids, or you have 4 people or 6 people having to come to a decision. And again, it gets really complicated. In fact, if you want there to be conflict in your family, there are probably worse ways that you could generate conflict than having a transfer on death deed. It's not always the case, and there are families for which it works, no question. In fact, I've written transfer on death deeds for families where I know that this is going to be a good situation and this is going to work. But oftentimes, if there are at least 2 kids, if there are more than 2 kids, having something, having a revocable trust where it's just one successor trustee who gets to make the decision about what's going to happen with the real estate makes much more sense. That one successor trustee can decide to sell the house, can decide we are going to keep the house and split the income generated from rent. Whatever the case is, it is just much simpler to have that one person making those decisions. Another question that I often get is about supplemental needs or special needs, and what special needs to happen for somebody with special needs or supplemental needs. There's something that you can write called an SNT. That's a supplemental needs trust. And the beauty of a supplemental needs trust or a special needs trust is that it can hold assets, it can hold an inheritance for somebody who is receiving government benefits and would normally be disqualified from that government benefit if they receive the inheritance directly. And that's what a lot of people don't know, is that if you direct inheritance, if you direct money to somebody who's receiving certain government benefits, just receiving those assets can knock them off of the government program that they are taking advantage of. And if that government program is paying for their home or paying for their food or paying for their health care, it can be extremely disruptive to that person who now needs to scramble and start making payments out of their own account, out of their own money, in order to continue enjoying that home or enjoying the food that they're used to, enjoying the medical attention that they are accustomed to. And what happens after that inheritance is spent? Well, the person has to reapply now for the government benefit, and it can take time. It can take a long time to get requalified and to get approved for that government benefit. The better solution is to have what's called an SNT. Again, supplemental needs trust. That supplemental needs trust can hold on to the assets, can hold on to the inheritance. The person can enjoy the money that is in that SNT. But the key is that they can't use the money in the SNT to pay for things like their home, like where they're living, if their living is being subsidized. They can't use that money to pay for things like food if they are currently having their food subsidized. It protects those government benefits, those government programs that they're a part of, but it gives them access to some additional money for things like luxuries and vacations and things that they enjoy and that they can use the money for. I'm not seeing a lot of questions, and so I'm going to go ahead and call an end to this webinar here tonight. Thank you for being with me. I will just keep an eye just to make sure that no questions come in just right at the last minute here. but I'm just not seeing any questions coming in. So again, I want to thank everybody for being here tonight. I want to thank you for giving me your attention and for taking the time to educate yourself and learn about this topic. I know at times this topic can be kind of scary, and I know that it can be overwhelming and a lot to learn. But again, I want to commend you for being here tonight. I want to commend you for learning this information. I really hope that you will sign up for a family wealth planning session with me where we can continue this conversation and we can make it specific to your particular situation. Again, I know, unfortunately, I don't have a lot of those before February, but I hope that you plan to meet with me in February or in March when it works in your schedule, and that we're able to continue this conversation and get an estate plan in place for the people that you love. Again, thanks so much for being here with me tonight. Again, my name is TJ Scott. I am an estate planning attorney with the law office of Timothy J. Scott, and I hope you have a great rest of your night. Take care.